We have gone through the facts. We have also settled down 4 principles of law which are in consonance with the earlier that services of tainted candidates where appointment must be terminated and they will be required to refund any salaries or payments received. Since their appointments are a result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. For candidates not specifically found to be tainted, the entire selection process has been directly declared null and void due to aggregated violations and illegalities which violate Article 14 and 16 of the Constitution. As such, appointment of these candidates are cancelled. However, the candidates already employed need not be asked to refund or restitute any payments made to them, or the services will be terminated. Furthermore, no candidate will be appointed once the entire examination process and results have been declared void. Some of the appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of the state government or autonomous bodies, etc. In such cases, although the appointments are cancelled, these candidates will have the right to apply to the previous department autonomous bodies to continue service with those entities. Such applications must be processed by the respective government departments or bodies within 3 months, and the candidates will be allowed to resume their positions. Further, the period between termination of the previous appointment and rejoining will not be considered as a break in service. The seniority and other entitlements will be preserved, and they will be eligible for increments. However, for the period they were employed under the disputed appointment, no wages will be paid by the state government or autonomous process. This process must be completed expeditiously, and if required and necessary, this process must be completed within 3 months, and if required and necessary, by creating supernumerary posts for persons appointed in the interim. Lastly, we address the case of disabled candidates. Our attention has been drawn to one such case where the impugned judgment has held that the appointee, Soma Das, shall be allowed to continue on humanitarian grounds. While we will not interfere with this finding, we make it clear that other differently able candidates are not entitled to the same benefit, as this would contradict legal principles and the rule of law. However, in consideration of their disability, these candidates will be permitted to continue and receive wages until fresh election process and appointments are completed. The disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process, if required, with age relaxation and other concessions. Similarly, other candidates who are not specifically tainted will be also eligible to participate with age relaxation. In our opinion, such direction would be fair and just, as would allow these candidates to take part in fresh selection process, which would now be initiated to fill the vacancies. Our observations and findings would not influence the criminal proceedings. Accordingly, we uphold the impugned judgment, cancelling and block the entire selection process, but have made certain modifications in the directions issued by the High Court. Appeals are disposed of in the above terms. We, however, will independently take up the issue with regard to the appeals filed by the state of West Bengal with regard to the direction of investigation by CBI on the decision taken to create supernumerary posts. Especially petitions to this extent will be listed for hearing on 4th of April 2025. All pending applications, including implement application, also stand post of no order as to cause.
Grateful.
But can I seek my lord's indulgence, my lord, something which I cannot mention, my lord, in the mail, my lord, I'll have to mention, my lord, if your lordship permits.
Please.
There is one matter where, my lord, it's a huge parcel of land where we have, the central government has succeeded before the High Court. The matter long back was referred to a 3 honorable judges bench. And on my request, because, my lord, the government is planning some, my lord, international level manufacturing activity on that land. But because of status quo, we are unable to do that. It's a 3 honorable judges bench matter. On my request, it was placed before the bench headed by my Lord Justice Suryakant. But now, since there are no 3 judges bench, Lord, the matter could not be taken up. If your lordships can consider, my lord, putting that matter for a day, it would be over in a day, both sides.
The bench, all the 3 judges have already been nominated. Justice Suryakant is heading the bench.
My Lord Justice Suryakant is heading the bench. We mentioned and we said one session each will complete.
Just mention it before Justice Suryakant, whatever date he fixes, whatever directions will be there, we'll combine them.
Then I'll mention and then, my lord, trouble your lordships again.
Lord,
Right.
my lord, precious permission. One matter.
Why are you mentioning? Please move and mentioning slip.
This is a civil appeal, my lord. The registry did not accept a mentioning memo. Lord, this is a regular civil appeal.
Mention it by way of a memo or
The registry is not accepting.
they move an application for early hearing. That's it.
Ours is a part-heard, mine is a part-heard matter, it's a regular matter.
Maybe move an
It seemed to come up on the 5th of February.
Please
it didn't
move,
come up.
look, please. We can't help it. Sometimes part-heard matters also cannot be listed because of the other matters coming up. But whatever it is, if there is a matter which is to be taken up in the regular hearing, please move an application for early hearing. You can't mention it. I don't want to start this practice of mentioning again.
But my lord, regular matters, my lord.
Regular matter, move an application for early hearing. That's it.
My lord, here the issue is your lordships had already directed 1 year back to list it within 2 weeks. 1 year back. my lord.
Please move another application. That's it.
Lord, I wanted to make a personal request. In 104, I have sought the permission of all the other parties. I mean, Lord, it will be said not for today, only not for today. Everybody will be here, my lord, when it's called.
And the urgent matter of demolition of PW houses in Gurgaon.
Over the application or
No. And, we have, I'm just explaining on the order. The order was listed on Friday. Number 6 of that all matters to be listed before one matter. One matter was listed before another matter. But the order
I think the I've already spoken to me about tomorrow.
Today.
Those are they're not taken up. We'll start the matter tomorrow.
tomorrow.
Yes. One thing,
uncle is there.
sorry, this is
So long time guiding.
no, sorry, care of this All
Because she is the she action of the I will give
what's the relationship?
because job other
Father and the brother issue discussed.
well, the two matters are already there, my lord, that Mumbai,
Those
the petition was filed by the
we-
husband,
we-
my lord, not by the wife, my lord.
We will transfer those matters if the husband files any application. Next case, please.
Just one week.
Please, that's all, please. Nothing.
Item 2, my lord. I am
Very
for
fine.
the respondent. May I submit one thing, my lord? There is another transfer petition filed by husband. Let the both matters may be taken together, my lord. That is diary number 44349 of 2024. In that matter is notice is issued, my lord.
In that matter also notice is issued. On what date is it listed?
My lord, there's no date, my lord. Let this, that matter may also be listed with this matter, my lord, next week.
No, what is the date in that other matter? No date has been given. Has
I'll
notice
just,
been- It's a diary
notice-
numbers, but notice has
double-
not been issued.
Yes.
It's a
notice
diary
and stay, notice and stay is issued in that transfer petition, my lord. 44349. I have served to the other side council also.
with transfer petition.
44349, diary number
Diary number 44349
of 24.
of 2024, stated to have been filed by the respondent in the week commencing 5th of May 2025.
My lord, let me make a submission. In the said transfer petition, he has not mentioned that the present transfer petition is filed without mentioning and suppressing that he has
It
obtained.
is mentioned. It is mentioned.
This
It
is
is
the order.
mentioned. I will show it.
We'll see. Let it come up.
Obliged.
My lord, if I may, we are being led by senior advocate Mr. Vikas Singh in this matter. We are for the respondents. Can we
Lord,
question?
Let it be before the High Court.
No, the difficulty before the High Court will be, the High Court is bound by the final judgment of the single judge, which is pending before your lordship's page 333. Page
Let's request
333.
for a short pass.
No, but
And there is a-
we have already passed the interim order in that case.
Yes.
Will that interim order direction not be applicable?
No, my lord, the High Court is proceeding. I appeared last.
Sit down.
Only a minute, sir. No, not your matter, sir. It's,
Yes, Mr. Grover.
my lord, what has happened is, my lord, there is a judgment dated 4th of.
I'm aware of that judgment. We are aware of that judgment.
So, learned single judge who is listening the fresh matter now will be bound by this, cannot take a different view. That judgment is pending before your lordships, which is at page 333. Your lordship's order, plus a similar.
Four point one and 4.2 are bail applications.
Yes, please. How long?
More than 11 years, my lords.
No, 11 years is with remission or?
Remission, with the remission. Actual undergone is
But may I just
8 years in odd and 7 years in odd.
may I just hand over the custody certificates? They may not be on record, my lords.
What is the custody certificate that you filed? That's in, as on 7th August 2024.
Please.
The actual custody is not what you are saying.
Actual custody is how much?
My lords, the actual would be, the total imprisonment is around 7 years, my lords.
Try is 7 years, 11
And
months.
then
No?
earlier the applications were rejected. We are not, just wait for some time.
2 persons killed.
We are not inclined
My
to
lords, the
accept,
main accused have already been granted bail.
we are not inclined to accept the present application for suspension of sentence. So the appeals shall be.
My lords, in that case, may I just request, your lordships have already fixed the main appeals by the previous order.
Which
If
state?
these applications can also be taken up.
Which state is the main appeal listed?
My lords, it was last listed on the 30th of January, pursuant to the order of 6th of September 24.
The main appeals will be listed for hearing.
Lords, then these applications may also be.
The week commencing, in first 10 matters, in the week commencing 28th of July 2025. In case the appeals are not taken up for hearing within a reasonable time, it will be open to the applicants, so applicants to file a fresh application for suspension of sentence.
My lords, may I request that these applications may be
No, not required.
obliged. my lords.
Grateful, my lords.
But CC has again filed a report. It is clarified not that there is no per day. It's actually per year, and I'm already short.
No, that application of yours is little odd. What you have done is you just simply calculated from November to March. But what you're forgetting is the period earlier there too. If you have there been shortfall in that, that's it. It's not but if you calculate it throughout the year, there will be no shortfall, even if you take the per day extraction into.
No, Lord, if your lordships ultimately hold in my favor, then I'll be.
That per day stipulation will continue, because if you take it throughout the year, it will be sufficient to cover up the.
Only
And
thing,
you
Lord,
yourself accept that in your application you had given that, but then you say it was not mandatory for me to give that.
Lord, now what I've done, I'll tell your lordships. I moved for amendment of that EC.
There is
Lord,
also an application for additional evidence making allegations against you.
I'm not even, it is filed yesterday, and all kinds of things, Lord. This is obviously
We don't know. We'll have to.
Questions of arrival.
Without even filing a reply, you make a.
All right, Lord, I can
that,
Lord, I can file a reply.
I'm absolutely
Lord,
clean and.
I'll file a reply. I'll file a reply to that. I'll file a reply to that. Lord, in fact, may I suggest one more thing? Your lordships have seen the NGT order. There is no adjudication at all. Either of Lord per day or this, just joint committee, when there were objections not considered. I don't mind, Lord, going back to
application for modification 49341 of 2025. We're not inclined to accept the prayer of the present application. And hence the same is dismissed. Which is the other application for additional evidence?
IA number 82267 of 25. They've been charged sheeted by ED for this very mine for illegal mining. And cognizance has been taken by the court. This is a material fact they ought to have disclosed to the court.
I'll file a reply to that.
Yes, we issued notice to one.
I will. You please stay back. You're sure, no?
What is the IA number?
This is 82267 of 25.
82267 of
25.
2025. Issue notice returnable
Lord,
within 2 weeks, within 4 weeks. In the non-applicant, including the applicant, will file reply within 2 weeks, rejoinder if any, within 10 days after service of the reply.
Lord,
relist
Your Lord.
after, relist in the week commencing
82267.
13th of May 2025.
Lord, would your lordships require UP state to file an affidavit?
I've said non-applicants, including the applicant.
Obliged,
My
grateful.
lords had directed MOEF to file an affidavit last time on daily quantity.
That has not been filed.
Their affidavit has been filed, but it's simply a